He has other people.
Okay, I'm back.
All right, so Mr. Gorman's here. All right, so let's see who else we have online. I see a screen for Lily Gorman.
Yes.
Okay. And I don't see actually her on the screen. Is Lily Gorman here?
I don't think she's doing a screen share.
Okay, so she's not participating as a witness in the case?
No.
Okay, so just for observation. That is fun. Is Lily, refreshed my memory, counsel? Is that one of the children of the parties?
No, she's my niece.
Your niece, okay. So she'll be observing. I see a V40 thin Q. Yes, sir. Can you see and hear me? Gentleman that's on the center of the screen, is that a witness in the case for Miss Gorman or Mr. Gorman, either one of you?
Not for Miss Gorman.
Okay, Mr. Gorman, will that gentleman be a witness for you?
No.
Okay, and then Shelley's iPad. Is that, do you anticipate that?
She'll be a witness.
But she will be a witness?
Yeah.
Okay, I'm going to move her into the waiting room. And then 44 MEE, is that a witness?
That's my mom, no.
Okay, and then Georgia Parents for Kids' Rights, is that a witness?
They're going to be recording.
Okay, that's fine. I can record. We can actually just do this. Mr. Gorman will broadcast it live on YouTube. So let me log in. All right. Very good. Now, Ms. Sartain, you're representing Ms. Gorman. You're present. Mr. Gorman, are you representing yourself? Do you have an attorney?
No, I do not.
Okay. You filed a number of motions for contempt, and those were filed starting in May of 2020. There are up to 10 motions of contempt for various times between May the 5th, May the 15th. And there's a response filed to those. There's also a motion to compel discovery and a response made to that. With that, obviously, your matter was set originally to be heard on a calendar, and that calendar was canceled due to COVID. So it's been reset for Zoom video conference hearing today, pursuant to the Georgia Judicial Emergency Act. All right, are we ready to proceed and go forward on the motion to compel discovery and the motion to contempt today, Mr. Gorman and Ms. Sartain?
Yes.
Okay.
Yes.
All right, Mr. Gorman, you brought the motion. Let's begin with the motion to compel discovery. Mr. Gorman, what is the issue in connection with the motion to compel discovery?
Well, the issue is that I've also filed a motion for reconsideration of the divorce and, the final outcome of the divorce, as well as the motion for modification of child support. So, you there?
Mr. Gorman, I actually just thought, can the Georgia Parents for Kids' Rights, can that person come online? Actually, they need to show their screen. I'm just thinking back because we've actually, my YouTube channel is the reminder of this, and I'm broadcasting on YouTube, and we actually have, there's no right to record under Georgia law unless you filed for a Rule 21 request under the Uniform Superior Court rules. So we generally don't allow for proceedings to be recorded. So who's recording the proceedings, Mr. Gorman? And what's the purpose? Is it a media organization? Have they filed any request? Who was that filed at, sir? And what's your name? All right, and where was that filed at? Who with? Okay. Did you provide a copy to our office? They do not provide that. So let us check on that, sir, before we begin the proceedings today to see if we can get a copy of that having been filed. So, right. Okay. Let me check. Okay. Let us check on that and we'll resume shortly. Let me check with the clerk's office. All right. Well, if everyone's can hear, then we'll start to reconnect. If you'll turn your videos on. Mr. Gorman, Miss Lily Gorman's back in the waiting room. Do you want me to admit her? She's not going to be a witness, you indicated, correct?
Right, correct.
I'll admit her. And then Brett Felina.
Yeah, he's going to be a witness.
All right, so he'll remain in the waiting room. If you'll communicate with him and Shelley's iPad, that they're in the waiting room until they're called as witnesses, okay? All right, Mr. Langevin, Mr. Langevin, if you can hear me. Very good. I did receive a copy from the clerk's office. The Rule 22 request was filed at 9:43 yesterday with Superior Court of Hall County. So thank you for ensuring that was filed. I apologize. They do not get it to us. Unfortunately, the file, it takes a few days to be updated from when things are received in the clerk's office on hard copy. As most things are handled by Peach Court, but this case was not available in Peach Court, I understand. Ms. Sartain, you received a copy of Mr. Langevin's request for the Rule 22 request to record.
I'm sorry, Judge. I'm having a tough time hearing you.
All right. I'm in the courtroom and I only have a mask on. It's an open courtroom. I only have a mask on because of my staff attorney and the sheriff's office officer that's in the courtroom with us, but I'll try to speak up. So
it may be my speaker, but I can't do anything about it. So did you ask me if I have a copy?
Did you get a copy, Ms. Sartain?
No, sir.
All right, check your email. I believe Ms. Roberts I'd asked her
Oh,
to
okay.
an emailed copy.
Where does it say he has to be there? It's just transportation. I mean, is that the only place it is?
All right. Ms. Sartain, if you'll take a moment to look at that. Mr. Gorman, you have no objection. Do you have any objections to the recording by Mr. Langevin?
No, I do not.
All right. Ms. Sartain, do you have any objections to the recording pursuant to the Rule 22 by Mr. Langevin?
No, sir.
All right, very good, Mr. Langevin. I'm going to sign an order that grants your Rule 22 request. So I'll sign that and put that in the file, and we can forward an email you a copy of that after the proceeding is done today to the GA Parents for Kids Rights at gmail.com. Is that a correct address, email address? And will electronic service be sufficient on that, Mr. Langevin, or do I need to place a copy in the mail? All right, thank you, Mr. Langevin. You can record, and as I indicated, since we do have a number of folks that want to be observers, I did go ahead while we're in court, but I've also shared this on our YouTube channel as well, so that anyone that's wishing to view the proceedings has an opportunity to do so via YouTube today. All right. Okay, with that, Mr. Gorman, let's begin with the motion to compel Mr. Gorman and Ms. Sartain. Mr. Gorman, you were proceeding to discuss the motion to compel when it dawned upon me that we needed to address the Rule 22 request for the recording. So I'll let you proceed. Before we do that, Mr. Gorman, let me have you raise your right hand since you're representing yourself. Do you swear or affirm the testimony you may give in this matter and opinion before the court to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, very good. All right, go ahead, Mr. Gorman.
Well, this has been a strange case going on moving forward and stuff like that. You know, I find myself in a position that I had everything that accusations that Miss Gorman slings at me, and upon the end of the original divorce final, we went through a process of changing the password for the Amazon and ATA account, and at this point, and part of the reason for my motion of reconsideration was the intrinsic fraud that Ms. Gorman's perpetrated on the court, and that she continues to hide things and not tell the truth about things. But at the end of that hearing, we went through the process of changing the passwords on the Amazon accounts, in which I always thought that her withholding my phone number that I've had since 1998 was just to separate me from my friends. But I came to the realization it was so that she was able to access the Amazon passwords and change the Amazon accounts. She held on to that phone number, and she's, since accessed multiple accounts of mine using the two-step verification process and the phone number 530-368-0908. So in that motion to compel, I'm asking that she provide records of her SMS records, which would show that, subsequent to July 25th, 2018, Ms. Gorman accessed using my phone number to access and, defraud Amazon of payments and stuff like that. And then further, she used that to accuse me of shutting down her business. So I'm asking for that. She's told the courts that she didn't go out and buy a new car, but I'm sure that her records would indicate with the credit card purchases and stuff like that, substantial down payments on new cars and big purchases and stuff like that as well. She's maintained throughout this entire process that she makes $1,600 a month. Her bank statements reflect that she makes upwards of $30,000 a month. So, this is evidence that would, certainly prove my case that she should be compelled to provide.
So let me go back and address a couple points. Ms. Sartain, can you hear me any better now?
Yes, sir. Yes.
Right, very good. So Mr. Gorman, actually in reviewing the motion to compel, and I apologize because this is kind of a dated matter in the sense I believe this was originally set perhaps back as early as April or so of this year, and then COVID necessitated cancellation because it was set to occur in person. And at that time, actually looks like I'm looking at a Rule 9 side that was in May of 2020. You have a motion for reconsideration of the final judgment and decree of divorce that's still pending and has not been heard by this court or any designated Superior Court judge, whether that be one of the magistrates sitting by designation or a senior judge. Is that correct, Mr. Gorman?
Correct.
All right. And Ms. Sartain, so this is pertaining, have you received a copy of the motion to compel discovery? This is pertaining to the discovery request or to compel the discoveries pertaining to that motion for reconsideration of the underlying final judgment decree. Is that correct, Mr. Gorman?
Yes.
All right. For the issues of the contempt, has there been any discovery requested to address issues of the contempt? I understood, and let me kind of preface it to say, I understood that the issues that are primarily sought address the lack of visitation that you're indicating, and
Yes.
that is why I have asked it to be placed on the calendar, and we placed it on the calendar to ensure that parameters of the child custody and visitation are being met. Are there issues within the contempt itself that would require discovery that you have not obtained, Mr. Gorman?
No, sir.
Okay. Mr. Gorman, understanding that the motion for reconsideration and motion for the modification is pending and has not had a final hearing on that matter, would you still be comfortable moving forward with the contempt matters today and then addressing the motion to compel discovery and the motion for reconsideration at a subsequent court date?
Sure. Yes.
Right.
Yes. That's just fine.
Ms. Sartain, I think that's the correct procedural posture here. Do you have any objections to that today?
No, I do not.
All right. We will look at when your motion for reconsideration was set for May and then was canceled due to COVID and not having in-person proceedings. We'll discuss at the end of today's calendar whether we would like to have that handled by Zoom or if the parties would like to appear in person for that matter. Okay?
Okay.
Right. So for today, we're going to go forward on the motion for contempt with the order still in effect at the present time and based upon the parties' direction to adhere to that order as it currently exists. So with that, Mr. Gorman, you've filed a series of motions for contempt that appear to pertain to visitation issues and having visitation with your children. So if you will go forward and I'll turn it over to you for any opening remarks you'd like to make on the contempt motions that are pending. Then Ms. Sartain will have an opportunity to make any opening remarks. And Mr. Gorman, you'll have the chance to present any witnesses and other evidence that you wish to present to the court. Ms. Sartain can cross-examine any witnesses. Then if you wish to testify, Mr. Gorman, you'll have the opportunity to testify. You've been sworn in by me. Ms. Sartain would have a right to cross-examine you in the event that you testify. And then upon the conclusion of your case in chief, Ms. Sartain will be able to present any witnesses and evidence on behalf of Ms. Gorman. And you'd have a right to cross-examine any witnesses and then present any rebuttal evidence at the conclusion of her case in chief. Okay, Mr. Gorman?
Yes.
All right, go ahead, Mr. Gorman.
So, well, I mean, we're here today because since the inception of this order, Ms. Gorman's refused to allow me any visitation with my kids. Prior to this order being in effect, I was able to see my kids on a similar schedule. I actually had more generous time with my kids, for the prior year and a half. Never missed a meeting, never was late. There was an occasion or two when I asked Ms. Gorman to spend some more time dropping them off at 8 versus 6 so that we could do an evening dinner, things like that. And, it was amicable. Since that time, Ms. Gorman's refused to let me see my kids. The last time I was able to see my children was January 17th. She allowed Larissa to come with me, but not Lauren, Larissa being my younger daughter. On January 31st, Ms. Gorman brought the kids to the drop-off location, and her boyfriend got out of the car, went back, and just took off. On February 7th, went to pick up the girls, waited until 4:45. Nobody showed up with the girls. February 17th, I was scheduled to see my children or at least Larissa for her birthday. Ms. Gorman refused to let me see my kids, stating that it wasn't my weekend and that I'm not allowed to see my kids. On the 21st, she refused to show up. February 21st, Ms. Gorman didn't show up. February 28th, I received text messages from my daughter stating that, I wasn't there to pick her up. February 28th was the fourth Friday of the month and therefore not my weekend. Actually, and also, mind you, on February 13th, I received text messages from Miss Gorman saying that I no-showed again, and she even sent me pictures of my daughter being disappointed and crying. That was the Thursday the 13th. They had a long weekend, but she's told my daughters that I wasn't showing up to pick them up. Friday, March 6th, went to pick up my kids. Again, they turned around. They went to the meeting place, turned around and left with my kids in the car. I got the sheriff's department involved, and she still refused to turn over the children for my weekend visitation, even with the sheriffs coming to the house. February 13th or March 13th. March 20th, went to pick up the girls, arrived at 2:45, waited until 3:15, no show again. Spring break, Miss Gorman sent me a text message saying that because of COVID that she wasn't going to let me see my kids. I responded with a copy of the governor's order that explicitly said that, the child visitation would not be affected by the COVID, and that, prior court orders in the Superior Court will all be upheld. Repeated texts to Miss Gorman that went unanswered, trying to find out when she was going to let me see my kids again, but she just never responded. April 17th, she showed up and then took off again as well, with the kids in the car. At that point we started, talking about summer vacation and stuff like that. May 1st, Allison showed up for the drop off, and then left again. Same thing. She still shows up, but she just doesn't show up. Doesn't let the kids get out of the car. She repeatedly tells the children that I'm supposed to be at the drop off. May 15th, same story. Miss Gorman showed up with her boyfriend and stuff like that, and just waiting for the girls. May 24th, I was supposed to have the kids for a prearranged 2-week visitation. And this is where it really got bad, is, her boyfriend started, calling me out in front of the children, and, then backed up and took off again as well. And at that point, with the escalation of her boyfriend and, getting more and more combative, we decided to call it off and wait for the court. And wait for a hearing from the court, because the abuse that my children were witnessing was just too much.
That was the May 15th date then, Mr. Gorman?
It was May 24th.
So the last one was filed on May the 15th?
Yeah. So I feel like I'm just wasting everybody's time. I've wasted the sheriff's department coming out for 2-hour calls that get nowhere. I'm a father first, and I'm just sickened as to the abuse that's going on with my kids and not letting my kids. I'm no longer a parent because of this divorce, but I still think that I should have a relationship with my kids, and it'd be meaningful and prosperous. It's just been very traumatic for me, and if it's this traumatic for me, it's certainly that much more traumatic for my children.
All right, so thank you for the opening statement, Mr. Gorman. We'll move into evidence in a moment. Ms. Sartain, opening remarks at this time.
Yes, just briefly. The parenting plan says the parties are supposed to be present for the exchange of the children. Also, there is a permanent protective order in place that says clearly that the father is to be present for the exchange of the children. The father had indicated to the court previously that he was living under oath. He was living in Utah. We don't know where he lives now, what his situation is. We had understood that he had indicated that he was homeless at this time. But all of these times that Miss Gorman has gone to meet Mr. Gorman, he's not there, and that's clearly against the court orders. She's not required to turn the children over. The visitation was for the father. And in fact, what's happened is the father's just never there. These are his, I guess, his witness, his sister Shelley, perhaps his mother. But Mr. Gorman just historically has not followed the orders or the instructions that the court has given him, and continues to basically just rail against Miss Gorman. He was represented by counsel in the divorce and in the permanent protective order case, and so Miss Gorman is not in contempt. We did not file cross contempt against Mr. Gorman, but he has not paid child support. He does not provide health insurance. He does not do any of the things. He's not paid the attorney fees he's ordered to pay. Our recourse there, we believe, will be to go back to Judge Burroughs and file contempt of the PPO, permanent protective order. But here, and because of Mr. Gorman's refusal to do the simple things that the court asked him to, it has caused my client a great deal of inconvenience. And in fact, we're asking at the end of this hearing today that Ms. Gorman no longer be required to go to the appointed meeting place, because Mr. Gorman is never there, and let's just suspend the visitation for the time being, because it's not fair to just make Miss Gorman come and show up and Mr. Gorman not be there. We're also going to ask, he filed this he didn't need to file 10 or 12 different contempts, but he did. We had to go through the process of answering each and every one, and Miss Gorman is going to be asking for her attorney fees.
All right, thank you, Ms. Sartain. All right, Mr. Gorman, you can proceed with evidence. So let's just be clear, and I want to go back and recap for a moment that the final judgment decree of divorce was entered on December the 31st. An amendment was entered that's filed on January the 17th, but that doesn't affect in any way the parenting plan. The permanent parenting plan was entered on December the 31st as well, which provided for the parties having joint legal custody of the two children. Two female minor children born in 2008, 2016. So having joint legal custody and the mother being the primary physical custodian, with parenting time for Mr. Gorman being the first, third, and fifth Friday of each month. That would be set from the release of school or 3 p.m. until 6 p.m. on Sunday. Then it provided for applicable holiday visitation for Thanksgiving, Christmas, summer vacation schedule as well. My understanding of the summer vacation schedule from my review is that each of the parties were to have 4 weeks with the summer vacation, so those would essentially be dividing the summer 50-50. They're importantly supposed to meet at the Flowery Branch Police Department for the meetup and exchange of visitation, and that was due in part, Ms. Sartain, you touched upon that Judge Burroughs did enter a permanent protective order following the 12-month protective order against Mr. Gorman that Ms. Gorman had taken out.
Yes, sir.
A permanent protective order was entered by Judge Burroughs, which is why I've indicated for the parties to meet at the Flowery Branch Police Department. All right. And Mr. Gorman, in your motions for contempt, you've indicated that Ms. Gorman has failed to provide and make the children available to you on each of those dates alleged. Is that correct?
Correct.
All right. Have you been physically present for those pickups, Mr. Gorman?
Your Honor, Ms. Gorman has made allegations in the past that I've tried to make contact with her over the protective order. This has been certainly a crazy railroad, but Ms. Gorman alleges that there's been contact, which there never has been any contact, and therefore I'm afraid to actually show up to be physically present. There is no order that says that I need to be physically present at the pickup and drop off. In fact, in the permanent restraining order, it directs my daughter's grandmother to be at the pickup and drop off location, for which she has been present for the pickups and drop offs as well. So,
what is her name, Gorman?
Pardon me? Nancy Shelley.
Nancy Shelley. All right. I'm going to need to get a copy of the permanent protective order that was entered by Judge Burroughs, so I'll review that. Mr. Gorman, on your motions for contempt, I note that they generally all follow the same format, but it indicates on May blank 2020 waited at the Flowery Branch Police Station. You don't indicate that you waited. Would you be able to fill it?
That's correct. I was present in town. I just wanted to see my children.
Okay. All right. Mr. Gorman, you can proceed with evidence that you have in the case at this time. If you'd like to call any witnesses, you may do so at this time.
Yeah, I'll call Shelley Gorman.
All right. I'm going to bring Miss Gorman in. All right. Miss Shelley Gorman, if you're on the screen, if you can hear me, if you'll activate your video. All right. Good morning, Miss Gorman. Can you see and hear me okay? I cannot hear you. Let's try, if you'll try connecting your audio one more time, Miss Gorman, because I can see you and you're not muted, but we can't hear you. All right, we'll see. Miss Gorman's video is out. I don't believe her audio is connected, so I've sent a message to her asking if she would connect her audio.
Could I just ask, Your Honor, while we're waiting for this, do you have a copy of the family violence permanent protective order?
I just asked Roberts to get that, so she's printing that out for me now.
Okay. Because I did want to advise the court in paragraph 12.
All right. Miss Shelley Gorman, can you hear and see me okay?
I can hear you. Can you hear me now?
I can hear you perfectly. All right. And you can see us okay, correct?
Yes.
All right. Very good. Miss Gorman, we're going to start with you in just one moment. Miss Sartain, you were saying?
I just was pointing out in response to Mr. Gorman's comment that paragraph 12 says for all visitation, parent A, which is Mr. Gorman, must have the children in his physical custody. If he is not present for the entire visitation, he will lose all visitation until further order of the court.
All right, Ms. Sartain, we'll address that. You'll have an opportunity to address that perhaps on cross and on your case in chief. All right, Ms. Shelley Gorman, if you'll raise your right hand, please. Do you swear or affirm that the testimony you may give in this matter and opinion before the court to be the truth, the whole truth, and nothing but the truth?
Absolutely.
All right, you can put your hand down. Mr. Gorman, if you have questions of Ms. Gorman, you can proceed at this time.
Hi, Shelley. What's your relationship to the children?
I am their niece, their auntie.
Uh-huh. Okay.
I mean, they're my nieces.
All right. So you have been present for the pickups and drop-offs of Lauren and Larissa?
Yes.
Okay. So On January 17th, you went to go pick up the girls. That would have been the first time since the order. Did Allison allow both Lauren and Larissa to come with me?
No, no, only Larissa, because Larissa saw me, got out of the car and ran to me so excited. And I think it was kind of, I don't know, but it was great to see her.
Was I present at that pickup and drop off?
You were at home waiting for us to bring the girls back.
Okay. On January 31st, you went to pick up the girls. On the next time, what happened that time on January 31st?
I think that was the one that they drove up and drove off.
Okay. How about
there were times there were different dates and I can't remember them off the top of my head, but they were there and then they were not there. And I don't know.
On February 7th, you went to go pick up the girls. And the notes indicate that nobody was there to drop the girls off on February 7th. Is that correct?
Yes.
On Thursday, February 13th, we were at the house and I got a message from Lauren that I wasn't there. Did you go to pick up the girls on the 13th?
Yes. What happened was they said Lauren said that we weren't there and we were just there. I think that was that one day. I can't remember which day it was because they're all something happened different every time just about. But one particular day, if this is the day that you're talking about, she was there and then we were like, we'll be right there because it was the weekend that you didn't have them. And she said that you weren't there. And we said, we'll be right there to get you. Wait there. And they didn't wait.
Okay. But we were ready to see the girls at any extra time that she would give us. Anytime. Okay. 17th doesn't apply to you. On the 21st, you went to go pick up the kids at 4:00 for the visitation weekend. Did anybody show up? 21st of February.
I wish I had the videos to see that date.
So, but no, we didn't.
No.
I understand he's self-represented, but he's not permitted to answer for the witness or lead the witness.
I'll sustain an objection for leading. So, Mr. Gorman, you can't direct Ms. Gorman, and you'll have a chance to testify yourself. But Ms. Shelley Gorman, just testifies to what you recall and what you know. If you don't recall, just answer that you don't recall. Mr. Gorman, you can try to clarify, but you can't lead the witness in a leading style question. Okay, Mr. Gorman?
Okay.
Go ahead.
All right.
When it comes, can I say something? I'm sorry.
No, just hang on a second. On March 6th, we were scheduled to pick up the girls and nobody showed up. And March 6th, you were with me when I called the police, correct?
Yes.
You assisted with trying to get the kids from the house at the house at the 3919 Crimson Ridge Way, correct?
Yes.
Did the police arrive?
Yes.
Did the police go to the house do you know if the police made contact with Miss Gorman?
Yes.
What were the results of that?
They were going to hold her accountable for not letting the kids due to the permanent restraining order where it says it is enforceable. But then she brought up the divorce order. And so the divorce order was the most recent order. So the police officers went by the most recent order.
And the police officer said that the permanent protective order didn't apply in this custody situation?
Yes.
Okay. Friday, March 20th, you went to go pick up the girls. They weren't in school on March 20th. You went to go pick the girls up on the 20th. Did anybody show up to drop the girls off?
No.
April 3rd, that was the first week of spring break. You went to go pick the kids up on April 3rd. Did anybody show up?
No.
Friday, April 17th, you went to go pick the girls up.
Yes.
Did anybody show up on the 17th?
No.
May 1st, did anybody, that was a scheduled weekend, did you go to pick the kids up on May 1st?
They showed up and they drove off.
May 15th, you went to go pick up the girls for the visitation weekend. Did anything happen there?
I believe that was the time when the kids were out of school, and the time was different because they were out of school. You got to pick them up earlier, so we showed up at an earlier time, and they were not there. And then they said there was still school, and then we ended up coming back at 4, and it was a show up and take off, drive away again.
Okay. May 24th, you went to pick up the kids for their 2-week visitation schedule for the summer vacation. Could you explain to the court what happened that day?
We showed up to pick up the kids. They showed up. We always showed up early, and they showed up early this time. And I had a conversation with her boyfriend, and he was telling me, where is he? You know,
Hearsay.
I have video.
Object to hearsay.
I'll sustain the objection to hearsay, so you can't say what he said to you, Miss Gorman, but you can testify about your reactions and your behavior.
I said to him, I said, why are you not picking up the girl? Why are you not dropping off the girls? I said, my brother has a permanent restraining order. He cannot be at the drop off. And I also said, because they had my niece in the car with them, I also said that they're lying about her father not being here. And I have video.
Your Honor, can I get Ms. Gorman to identify a video, and we could watch the video of that interaction?
If you have a video, Mr. Gorman, and you can lay the proper foundation with the witness that you wish to ask about that, if that's Miss Shelley Gorman, then you can seek to introduce that exhibit.
Okay, so you took a video of that interaction. There was you in fact have videos of every interaction, correct?
I do.
Do you think you could identify the video if I was to show it to you?
Yes.
You have the ability, Mr. Gorman. Do you have the video on your device?
I do have the video on my device. I've got a lot of videos. Oh, wait, there it is.
There is a screen share option with Zoom that you can share the screen, and then you could provide the video on the screen.
Okay, so I'm having a little bit of technical difficulties.
In the center of the Zoom screen, there is a green share screen button.
Okay.
and you can attempt to share your screen if you have the video pulled up on your device. All right, so your screen sharing. All right.
And
Now, if you would open the video. All right, just stop the video for a moment, Mr. Gorman, if you'll pause it.
pardon me?
Is this the video that you're wanting to ask Ms. Gorman about?
Yes, yes.
You'll make sure that she can identify this video, Mr. Gorman.
Shelley, can you see this video that's on screen?
Yes, I can.
Okay. Is this the video that you took
Yes, it is.
on May 24th?
Yes, it is.
Okay.
All right, are you seeking to introduce this as an exhibit, Plaintiff's Exhibit 1, Mr. Gorman?
Yes, I'd just seek to admit this as plain as Exhibit 1.
All right, Ms. Sartain, is there any objection?
No, sir.
All right, that'll be admitted. So you can play the video now, Mr. Gorman.
You can't hear what he's saying.
Is the audio on your device, Mr. Gorman? Can you look to see if you can adjust the audio?
And so there's no sound coming from it?
No sound on any of our screens.
Can you still see the video?
We can see the video, we just can't hear any audio from it.
Can you hear it now?
No, sir, we're still not hearing any audio. Why don't we do this, Mr. Gorman? Remove your screen share for just a moment, and we'll just give you a moment to try to pull the video up where it's playing on your computer, and then you can play the audio again. I don't want to have anyone inadvertently looking through your files or anything else that you may not want to be shared on the screen.
Sorry. Can the audio be heard now?
Let's try it, Mr. Gorman. I can't hear it, but you could try playing it. Let's see if you can play it and see if it can be picked up.
Did you hear it?
we're still not receiving any audio. And Miss Shelley Gorman, you're not receiving any audio, correct?
Can I email it?
If you email a copy to the court and to Ms. Sartain, Mr. Gorman, so email my copy to whitney.roberts@hallcounty.org. And you need to provide a copy to Ms. Sartain as well. You have her email address?
Yes, I think I do.
Can you share it from your phone?
And will you let us know if you do email the video, Mr. Gorman, when you've sent that email?
Meeting info. Is there a way to drop this into chat?
I don't believe that there's a way that I'm aware of.
Oh, here's a setting. I think I might have found the setting.
Okay.
The children at home.
Can you hear that?
That's it. We can hear that now.
I heard it.
Okay.
Right. So if you'll start the video back at the beginning, Mr. Gorman, since we found the audio issue. So now you can play it. This is Plaintiff's Exhibit 1. Go ahead.
He's waiting for the children at home. Why are you refusing to drop off the kids? Why are you not dropping off the kids? Why not? There's no order that says that. There's no order. They're lying to you, Lauren. He's home. He is home for his kids. We're just at the house.
Did you hear what Shelley, did you hear what he said at the end of that video?
He told me to tell you to man up.
He said that you saw my kids present in the vehicle when he said that?
Yes,
Do you think that was appropriate?
absolutely not.
Thank you.
And will you stop the screen? Do you have other videos introduced? If you'll stop the screen share. If not, then Mr. Gorman.
I have more videos, but I don't know how relevant they are. You know, but it's those interactions that happen numerous times over the 10 weeks, and that was kind of that's where I had to stop because that's not stuff that my children should see. So you know, that's it.
You'll have a chance to testify and make argument as well at the conclusion.
Right.
Gorman, so I'll certainly hear from you at that time. Any additional questions for Shelley Gorman at this time, Mr. Gorman?
I don't have any additional questions.
All right, Ms. Sartain, do you have questions on cross-examination of Ms. Gorman?
Yes, sir. Where does Mr. Gorman live?
He lives here with my mom.
How long has he lived there with
he
you?
works out of Utah, so he has to go in the office.
Okay. How long has he been living with your mother?
Since all this happened,
When did all this happen? What date?
July 18th, 2018.
Do you know any reason why he would have continued to represent that he was living in Utah?
I don't think he ever represented that.
Were you present for all of the hearings?
Yes, I was.
Okay.
He did not say he was permanently living there.
Okay. How many days a week is he in Utah?
When he's not able to see his children, he takes care of business because he has to work.
Yeah, that didn't answer my question. How many days a week is he in Utah on average?
I would say 7. If he's not here for his children, he had
Okay.
come every time that his children were to be with his visitation with the children, he was here every time.
Well, did you ever read the parenting plan that the court entered?
I did.
Did you see where it said the parties were to meet for the exchange and the transfer?
It says the parties are responsible.
And what's the next line say?
I don't have it in front of me.
Well,
But he's to be present at each visit, which he was. But why would a man go with a permanent restraining order to pick up his children?
Well, because you have the opportunity to.
That's not the
video-
order.
Excuse me.
Miss Gorman, if you'll answer the questions, and Miss Sartain will let you respond in full before our next question, but you can't ask her questions back, okay?
Mm-hmm.
Just as you've shown us, you're able to video the exchange. So if anything happened, there would be no question because you captured it on video. Isn't that right?
That is correct. And so did they.
Yes. Now, in the transportation agreement, did you see that it says that the parties shall meet at the Flowery Branch Police Department?
Right. The parents are responsible for that transportation.
Well, what does it mean to you when it says the parties are to meet? Nothing?
That means the parties who have the children are to meet.
Yes.
It doesn't,
Okay.
It's not specific.
All right. Well, and then in the permanent parenting plan, it does say that the father must have the children in his physical custody. If he's not present for the entire visitation, he'll lose all visitation till further order.
Right.
Okay. All right. So, Mr. Gorman, none of the times that you went to pick the children up was Mr. Gorman with you, was he?
No, because he has a permanent restraining order.
Okay. And, well, that's all I have.
All right, any redirects, Mr. Gorman?
Shelley, in your opinion, is it safe for me to go pick up my kids to have any interaction with Allison Gorman?
No.
Would you say that it's dangerous if I was to see Allison Gorman?
Yes.
When confronted with law enforcement in regards to the permanent restraining order, the permanent restraining order was enforceable to allow me to see my kids. However, when Ms. Gorman took out the divorce order, the law enforcement, how did they explain that to you?
I object. That's for the judge to decide. Doesn't matter what law enforcement said or thought.
Sustained. Your next question, Mr. Gorman.
I've got nothing else, Your Honor.
All right, anything further, Ms. Sartain of Ms. Gorman?
Yeah. One quick. Don't y'all meet at the police department in Flowery Branch?
Yes.
Okay. That's all I have.
All right, can Ms. Shelley Gorman be excused, counsel?
I have no objection.
Yes.
Ms. Gorman, all right, so with that, Ms. Shelley Gorman, you're excused, which means you can stay on the call. Just ask you to mute your audio if you stay on the call, or if you wish to view the proceedings by YouTube, you can do so, or you're free to leave at any point in time that you wish to leave, okay?
Thank you.
All right, thank you. All right, Mr. Gorman, you can call your next witness.
I'm going to call Brett Felina.
All right, I'm going to bring Mr. Felina in from the waiting room. All right, I believe we have Mr. Felina's connection. I don't see Mr. Felina. I think we're looking at the ceiling. I see a few ceilings on my Zoom days, some ceiling fans. All right, Mr. Felina, there you are. All right.
Yes, sir.
Can you see and hear me okay?
Yes, sir.
All right, sorry, I know we had you in the waiting room, so I hope you were able to make efficient use of your time while you were having to wait. One of the benefits
Yes, sir.
one of the benefits of Zoom, that you can actually still be accomplishing something else, hopefully, rather than sitting around a courthouse all day. Mr. Felina, you've been called by Mr. Doug Gorman to testify in the case. So I brought you in from the waiting room. What I want to ask you to do at this time is raise your right hand, please, sir. Do you swear or affirm the testimony you're about to give in this matter and opinion before the court to be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, very good. You can put your hand down, Mr. Felina. And is that correct? Is it Felina?
Felina, yes.
Felina. All right, go ahead, Mr. Gorman.
Hi, Brett. Thanks for joining us today. I appreciate you coming in. In March of 2018, you came out to live with Miss Gorman and myself, correct?
Yes, sir.
You stayed at our house for approximately, from April till, or March or April till the end of June, correct?
Yes.
Okay. During your time at the house, you had the opportunity to watch me interact with my children?
Yes.
You had the opportunity to get to know and become friends with Lauren and Larissa?
Yes.
Did you spend much time with Lauren and Larissa?
Yes.
Did you see me interact with Lauren and Larissa?
Yes.
Did they like spending time with their dad?
Absolutely.
Did you ever see any issues? And time with my time spent with the kids?
Not one time.
Not one time?
Judge, I'm going to object. I mean, I know you give leeway, but this predates the divorce, is not relevant. And number two, is not relevant to the issue of contempt.
Any response to that, Mr. Gorman? You understand Ms.
Well,
Motion?
I'd like to, I've been made to be a lot of things throughout this divorce proceedings, and a bad father is not one of them. And I think that, Brett testifying to this is, just to my character. So,
With Mr. Gorman, let me ask Mr. Felina, it sounds like Mr. Felina lived with you and your ex-wife for a period of time. But has Mr. Felina had interaction with you since January of 2020, since the divorce decree was entered?
He is, one of my go-to friends, and, somebody that I use for personal support through this, this trying time. This has ruined my life. So, I mean, I just, but yeah, he's been there every step of the way. He gets the phone call after, when I'm breaking down, not being able to see my kids, he's been the shoulder for me to cry on. And, he witnessed who I am as a father. I've known him. He's one of my oldest friends, and he's seen me through, my years of an abusive marriage, and, he's been there every step of the way. So.
All right. So what I'll ask you to do, Mr. Gorman, if there's questions that are relevant, we're here for a contempt matter today, so it has to be relevant to the proceeding at hand. If there's questions of Mr. Felina, can you hear me okay?
Yes. Sorry, I had to. Yeah.
I'm a little blurred with the mask on, but if there's questions relevant to the issues for contempt, those would be appropriate to ask Mr. Felina. Obviously, going back historically too far back to look at general observations is not relevant for the hearing today, but information we may be able to testify to about the contempt matters. Certainly you can proceed with questions on that end, Mr. Gorman.
I guess I don't have anything further for that.
Okay. So any additional questions then, Mr. Gorman, of Mr. Felina?
No.
All right. Ms. Sartain, do you have any cross-examination of Mr. Felina?
Do you know? Yes, Your Honor, I do. Do you know where Mr. Gorman is living now? Is he living in Utah?
I believe so. I think he visits back and forth. I actually don't know exactly where he is at this point. No.
Okay. All right. But it's your understanding that he basically lives and works in Utah. Is that right?
Yes, ma'am.
Okay. That's all I have.
Mr. Gorman, any questions of Mr. Felina?
No.
All right. With that, can Mr. Felina be excused, counsel?
I have no objection.
All right. Any objection, Mr. Gorman?
No.
Mr. Felina, I'm going to excuse you, which means you're free to go. It also means you're free to remain on the call if you wish. This is also broadcast on YouTube, so you're welcome to watch it on YouTube if you don't want to remain on the Zoom call. If you do remain on the Zoom call, I'll ask that you just mute your audio, and you can otherwise be available. But if you have other things to take care of, you're welcome to leave at this time, okay?
Thank you, sir.
Thank you, Mr. Felina. Have a good day.
Thank you.
All right, Mr. Gorman, do you have any witnesses that you wish to call?
No, I don't.
Hang up.
You wish, and Mr. Felina, yeah, you can hang up or I can remove you.
Okay, here we go. Leave.
Perfect. There you go. There we go. Mr. Gorman, do you wish to testify in the matter? You've been sworn, so if you wish to make a statement in testimony, you can do so. You're under no obligation to do so. If you do provide testimony, Ms. Sartain has the right to cross-examine you. Likewise, she could call you as a witness on cross-examination if you don't wish to testify.
I think my case, well, I'm not necessarily understanding how this works, but
let me give you.
I don't know if I could add anything new that hasn't been said.
Let me offer this, Mr. Gorman. Opening statements and closing arguments are not evidence in a case. They're simply opening statements and arguments. So arguments are not evidence.
Okay.
If you wish to introduce any testimony that would be evidentiary, you'll have the opportunity to do so at this time. Okay.
Okay. Yes, I would. So.
Go ahead, Mr. Gorman. You've been sworn.
Okay. Well, I've of course, been reduced to being a visitor and not a parent anymore. But, I've been here every step of the way to see my kids, been here for every scheduled weekend. I've never stopped wanting to be a parent. And, the mere fact that my kids have been ripped away from me has traumatized my life. I find myself not being able to function, not being able to get the jobs done that I need to get done. I live in fear because of what Ms. Gorman's done. And, the potential, if I were to actually show up at one of these meetings, for Ms. Gorman to not represent the truth as far as what happens at these meetings. Even at the Flowery Branch Police Station, it's proven not to be a safe space because of the nature of what she's accused me of. Ms. Gorman, one of my motions for contempt was on April 25th, Saturday, April 25th at about 10:15. I was having a conversation with my daughter, and Mr. Smith jumped on the call, accused me of being a wife beater, which has no merit.
I object.
And in front of my daughter.
Out for a moment, Mr.
Right.
Sartain objected. I'll sustain the objection, so don't testify to what anybody else has told you if they're not available to testify, but you can.
Right. He's, Mr. Smith makes disparaging remarks about me in front of my children. In the divorce party, and in the parenting plan, it says neither party shall accuse the other parent of being at fault or in the presence of the children. Neither party shall make negative or disparaging remarks about the other while the minor children are present, nor shall they allow others to do so.
Okay. Anything further, Mr. Gorman?
No, that's it.
Okay. Ms. Sartain, do you have questions on cross-examination of Mr. Gorman?
Yes, sir.
All right.
Mr. Gorman, it is true that you have never been present to pick the children up at the beginning of an exchange since the divorce, have you?
Yes.
You're saying that's true?
I answered yes.
Yes. Okay. All right. And you personally have never heard Mr. Smith saying anything ugly about you in front of the children?
Yes, I have personally heard Mr. Smith say negative things in front of the children about me.
When?
The 25th of April.
Okay, and you said that was a phone call and you were on the phone with the child and Mr. Smith got on the phone?
Yes,
Okay, all right. Now, you live primarily in Utah, do you not, sir?
no,
Well, and wasn't that part of the reason at the both hearings, the permanent protective order and the hearing for the divorce, that you were living out in Utah? You told the court you were making basically minimum wage, and the court wanted the visitation to be between you and the children and not your mother and not your sister and the children. Do you remember that?
that's not true.
Okay, so you're saying you don't remember that?
No, I'm saying that that's not true.
Well-
Your statement's not true, ma'am.
Okay, all right.
So what during the divorce hearing, can I answer?
You can go ahead
Feel
and expand
free.
on that,
Okay,
sir.
during the divorce hearing, I was living in the Hull County Jail.
Yes.
During the temporary or the permanent restraining order hearing, I was living at my mom's. I had just gotten out of jail a couple days before that.
So you never told any of the courts that you were living out in Utah and flying back and forth?
No,
Okay. Do you have plane tickets to show your flights back and forth between Utah and Georgia to confirm that you were in Georgia during the times of the visitation?
yeah. I mean, I could provide plane tickets.
Okay. Do you happen to have any there with you, or there's someplace else?
There's someplace else.
And where are you today?
I'm in the living room
The living room is located where? What state?
in Georgia.
Okay, all right. Okay, so there's never been a time that you were present for the visitation exchange that Miss Gorman didn't allow the children to go with you?
So the last time I was present at a visitation exchange, Miss Gorman accused me of trying to make contact with her.
When was that? Before
That was January 3rd, 2019.
Okay, before.
Hang on a second. I can look this up real quick to give you an exact date.
Before the divorce decree was entered and before the permanent protective order was entered, isn't that correct?
Ma'am, I am very fearful of interaction with Miss Gorman.
I understand all that. I'm just asking you about the date when the last time Miss Gorman was present with the children for you to pick them up. You're saying was January 3rd of 2019. Is that
as I recall, yeah.
okay? And these orders went into effect after that. Isn't that true?
Well, these orders don't say that I'm there to pick up the children.
I understand that. I'm just asking you.
Yeah. So yeah, we keep going to the same question. Yes. I have not been there. I can't.
Okay, that's all I have. Oh,
So
Judge, are you speaking, Your Honor? That's all I have. I have no more questions.
I'm actually asking Mr. Heck to inquire about something relevant to the case. So I apologize if y'all see my mouth moving behind the mask. I'm not trying to talk to y'all. All right.
I thought it might have been a Sotomayor moment.
No, thank you, though. All right. So no additional cross-examination then, Ms. Sartain?
No, sir.
All right, Mr. Gorman, anything in response to the questions that Ms. Sartain asked that you wish to clarify?
I think we clarified it.
All right, so Mr. Gorman, do you have any additional evidence to present at this time?
No, I do not.
All right, very good. With that, is the evidence closed at this time? Or the state and chief is closed. You rest at this time?
Yes.
Ms. Sartain, on your case, do you wish to call any witnesses at this time?
No, sir, because I don't believe Mr. Gorman has carried his burden, so we rest.
Okay, I will, the defense is rested, the respondents rested, allow for arguments at this time. So Mr. Gorman, you can proceed. You have the right to open and conclude since you're the petitioner on the case and you have the burden. So if you wish to make an opening closing argument, you can, and then you also have the right to conclude the closing argument portion, or you can waive the right to make an opening closing argument and just conclude. Which would you prefer to do?
I'll do an opening and closing.
All right, go ahead, Mr. Gorman.
So, of course, Your Honor, we're here for contempt. Ms. Gorman just flat out refuses to allow our children to have any visitation with their father. Ms. Gorman, doesn't care that there's a court order. She does not want to have any interaction between the father and children. All major studies have shown that children, especially young girls, need both parents and need their mother and father. So far, throughout the course of this divorce, Ms. Gorman has done everything that she can to try to keep me from seeing my kids, to keep me as far away from my kids as possible, and to not allow me to be a parent. She has, demanded loyalty from my daughter, Lauren, and doesn't allow for any room besides that loyalty from my daughter to her. Ms. Gorman, has been able to drop the kids off, but refuses to do so. She ignores the fact that, Lauren grew up with her grandmother and auntie for the last 11 years and has separated my kids from any extended family that they have here in Georgia. And with that being said, Your Honor, I just want to see my kids. I just want to be able to be a father, to be a dad, to interact, to watch them grow up and be a part of my life. That's all I have for now.
All right, thank you, Mr. Gorman. Ms. Sartain, closing argument.
Life would be so much simpler for Mr. Gorman if he got off his soapbox about complaining about Miss Gorman. If he wants to be a father to those children, he can follow the court orders. This is why we have a permanent protective order, because Mr. Gorman, even as late as today, blames his wife when the court has laid out clearly how visitation is to take place. Just because Mr. Gorman doesn't like it, he's the reason he has no relationship with his children, because he will not do what the courts tell him to do. And all he can do is blame his wife, his ex-wife. I'm saying, Mr. Gorman, grow up. Accept responsibility for your own actions. If you want to visit with your children, be there. And Your Honor, I believe Mr. Gorman's credibility has been impeached, because I believe the court will recall, even though you've had a bunch of these, Mr. Gorman to just pretend that he never said anything about Utah. It's our position that most likely Mr. Gorman was never even in the state. But that's why both courts said he had to be present to be sure that he was here to exercise his visitation. That's all he has to do. That's not on Miss Gorman. That's not on Jesse Smith. That's on Doug Gorman. And until he understands that he is the one that needs to start doing what the court orders and stop blaming his ex-wife. Do what you're supposed to do and see if that doesn't work better for you. She is not in contempt. She has once again been harassed by this man, and we would ask, I'd like to state in my place that she has incurred $2,500 in attorney fees having to answer each and all of these separate things. And then we're going to have to come back where he's improperly filed a motion to compel in a case that's closed and all those things. But for today, this was not a hearing for everybody to, listen to Mr. Gorman cry again like he has all the time. This was a hearing where he filed for contempt to say Miss Gorman violated a particular provision of the decree, and she has not. He did not carry his burden, and the case should be dismissed.
All right, Mr. Gorman, final closing argument.
Yes. Your Honor, it's clear that Ms. Gorman's violated and willfully violated this court order. Your court on November 12th, 2018, made the statement that it doesn't matter who picks up the kids or not, as long as the parents are present for the visitation. There has been no order that says that I have to be present. In fact, the permanent protective order maintains that the grandmother picks up the children and not me in the permanent protective order. Ms. Sartain is speculating of my whereabouts. Ms. Gorman, I don't know. I'm lost with it. Unfortunately, when we talk about our kids, it's always emotional, whether it be a positive or negative. And there's been no compelling reason. I need to point out that there's a permanent protective order for no violence. It amazes me every time I see that, but that goes to, the fraud and deceit. But anyway, with that, it's in my prayers that the courts find that Miss Gorman is found in willful contempt of this order, that Miss Gorman is reprimanded for allowing her boyfriend to influence my children and say bad things about me in front of my children. We saw that with the video, him calling me out in front of my children when he was dropping the kids off. And Miss Gorman showing up for the meeting place on days that I'm not even supposed to be there and disappointing my children. So, and the continuing with the narrative that I'm not there to show up for the kids, therefore I don't care about my kids. That's it.
All right. Thank you, Mr. Gorman. All right. Mr. and Miss Gorman, I'm going to talk to you for a moment. Ms. Sartain is not a reflection upon you. This doesn't go to you. It goes to Mr. Doug Gorman, Miss Allison Gorman. Mr. and Miss Gorman, I've practiced law and been around the law as a judge and an attorney for 12 years, and I've never seen two parties that are as petty as the two of you are towards each other. It's ridiculous, honestly. It makes me incredibly frustrated to see that y'all are playing games with your children's lives here because of your bitterness towards each other. That may be more on one side than the other at various points in time, but it's worked both ways, candidly, between the time of your marriage, your divorce, and even to now. This is not a game, Mr. and Miss Gorman. This is the lives of your children, and it is incredibly frustrating to me that we're here today dealing with the two of you continuing to play games with one another. That's what this divorce case was. I can't speak to the proceedings before Judge Burroughs. Judge Burroughs has been doing this for a very long time. He's entered a permanent protective order. Mr. Gorman, I took that parenting plan at the time of entering the final decree, waiting on Judge Burroughs, knowing that he had a permanent protective order, and essentially addressed the visitation plan, finding that I did find that it was in the best interest for Miss Gorman to be the primary physical custodian, awarding joint legal custody. So you have rights to contact any school providers, medical providers, and get all of the information, and that Miss Gorman would have an obligation to provide that to you. But I even added to Judge Burroughs' plan to provide for additional summer visitation. So I believe Judge Burroughs had provided for 2 weeks. Non-consecutive, I provided for 4 weeks. So y'all were splitting what would be the summer visitation period and providing for the first, third, and fifth weekend. I'm going to find today, and this is going to be a kind of a two-part order, Ms. Sartain. You're going to draft the order. I'm going to find that Mr. Gorman has not met his burden in showing that Ms. Gorman is in willful, intentional contempt. That being said, Ms. Gorman, there's no reason that Mr. Gorman shouldn't see his children. Mr. Gorman, I'm expecting you to be there to see your children. And the reason that I put in there for it to be the Flowery Branch Police Department was so that there would be no issues about issues of what she may say about you appearing, that there's law enforcement immediately there. But realizing you're still not comfortable with that. And I can understand that from you today, that you don't feel comfortable even being outside of the police department. So what I'm going to do, Ms. Sartain, is I'm going to sua sponte modify the divorce order so that it states that their visitations to occur as ordered in the parenting plan, but that the meetup location shall be the Hall County Detention Center public lobby, and that the parties shall come inside the Hall County Detention Center lobby. The parties, meaning Miss Allison Gorman and Mr. Douglas Gorman, shall appear inside the Hall County Detention Center lobby to pick up and drop off the children. That lobby, as far as I understand and am aware, is open 24/7 because individuals come to the detention center to meet up with family or to discuss matters with the detention center. And there is no reason that Mr. Gorman and Miss Gorman could not go to that detention center lobby and meet in person. And then that is not to have Miss Gorman having anyone other than her dropping the kids off. And Mr. Gorman, you're to pick the kids up and drop them back off. So it will be clear that the two parties, and we'll name them on the order, Ms. Sartain, that Douglas Gorman is to pick up and drop off. Allison Gorman is to pick up and drop off. No representatives. I'm not opposed to representatives. Candidly, I value that family needs to be involved and engaged. But Mr. Gorman and Miss Gorman, we can't get there with y'all because this is such a huge cluster that I can't be that flexible with you. I have to lay out in concrete black and white because the two of you can't give an inch to the other side in order to be able to have any degree of co-parenting. So I'm going to make it very clear and specific that the transportation meetup will be for all visitation at the Hall County Detention Center lobby. I want to get the detention center address so that I can have that, and I'll include that in the order. 1700 Barber Road, 1700 Barber Road, Gainesville, Georgia. Mr. Gorman, you'll be there. Miss Gorman, you'll be there. No one else is to come inside the lobby. No one accompanying you. Mr. Gorman, here's what I want you to do. Ms. Sartain, I want you to include this in the order. Mr. Gorman, you need to arrive 15 minutes early before the visitation. That way you're already inside the building. And then Ms. Gorman and you will not be walking in at the same time. Ms. Gorman, you're to wait 10 minutes after Mr. Gorman leaves before you exit the building. So there's no chance that the two of y'all have to meet at the door, the threshold of the door together. That you come in first, Mr. Gorman, you leave first with the children. Miss Gorman, you come in after Mr. Gorman's there, you drop the kids off, then you leave. All right. Ms. Sartain, I'm not going to find any contempt. I'm not going to award attorney's fees today. So I'm not going to issue an award of fees. Is there any question, Mr. Gorman and Ms. Sartain, about that order?
Well, I get to see my kids tomorrow.
Which weekend is scheduled? Is this your weekends on the first, third, or fifth weekend, Mr. Gorman?
Yes.
If it's the first, third, or fifth weekend, all provisions of the order otherwise remain in effect, in full force and effect.
Okay, and that's fine. And but with the him not, would the court hear from Miss Gorman just on this visitation thing, since I didn't need her to testify on the contempt? The children have not seen their father in over a year. The little one has been diagnosed with a little bit of an issue, and perhaps this first visit would begin as kind of a phase in. What are your thoughts about that?
I object to that, Your Honor. Your orders have been placed, and if she wants to file another motion, she should file another motion.
Ms. Sartain, I'm going to stick with the order.
Okay.
And they need to arrange for their visitation to occur. If it's on that schedule, it's going to occur there. If Mr. Gorman is not there in person, then he forfeits that visitation. Likewise, Ms. Gorman is not to have anyone else do the drop-off or pick-up, so she's not to have a boyfriend do that on her behalf. Okay?
Okay.
Both sides can have video cameras walking in and out of the building. They can have video cameras in the sheriff's office lobby. The lobby's recorded, as Mr. Heck points out to me. So if there's an issue, then they need to file a police report right there on the spot. And going forward, the most reliable evidence that the court can rely upon is a police report and an officer to testify about that report. So if Mr. Gorman, you think Ms. Gorman's not done her part, or Ms. Gorman, you think Mr. Gorman's not done his part, file a police report, because you're already at the detention center for that time period. All other provisions need to be complied with, because candidly, Mr. and Ms. Gorman, I'm at the point where if y'all come back before me and either of you are continuing to be petty and you're not complying with the court's order, I may put either of you or both of you in jail, as that's the power of the court. And I've never had to do that, thankfully. I've certainly sit in courtrooms as an attorney and watched it occur. I've never had to take that step of saying that I'm going to put civil parties in jail for contempt. But because I have a high level of patience, I believe, and a fairly high tolerance. But the two of you need to do better for your kids' sake, because this is, I don't know. I can't measure the bitterness. I can't explain it. I said, it's just very frustrating. I get tongue-tied at how frustrated I am by this situation. All right, Ms. Sartain, I'm going to ask you to prepare that order.
I'll do it.
You to email it over to me, and then I'm going to sign that. And Mr. Gorman, I assume we got a good, valid email address for you. That's how you've been getting hearing notices.
Yes. Your Honor, would it be too much to ask that whatever modification that it's enforceable by law enforcement and direct law enforcement to act? Because like I said, over the course of the last 8 months and not being able to see my kids, law enforcement has done nothing to enforce any order.
Well, I think every order is enforceable, but Mr. Gorman, if you feel that there's a violation, you likely need to bring a contempt action and bring it back before the court again. I guess I'm saying to both parties today, and we've got all types of things being recorded, so we can play it back. I guess I'm saying to both parties, if either one of you are willfully violating the order, you understand that the court can incarcerate you, that the court can order you to be held in contempt and held in custody until the court deems it appropriate that you've cured that contempt or that it will not be an issue in the future. I say that in part because obviously I would assume Ms. Gorman would not jeopardize her physical freedom and jeopardize the primary care of her children by placing herself in a spot where she would be held in contempt and potentially incarcerated. Mr. Gorman, I would hope that you would not jeopardize your opportunity to have visitation and be engaged in a meaningful way with your children by doing anything that would willfully violate and hold you in contempt. I will remind everyone today, Mr. Gorman, I don't believe that there's any pending contempt matters for support before me, but you understand that those are matters that you have obligations and responsibilities. I believe there is a motion for modification. And what I'm going to do as I speak to that at the end of today is that I'm actually going to go ahead and issue a rule nisi to both the parties for addressing the reconsideration and the modification matter. I believe that I've got a really crazy full calendar, but I believe we've got some special sets that have settled. So in the month of September that have settled now that may not need to go forward. And so I'm going to try to plug in this case on one of those dates so that that will be heard sooner than later. Okay.
And what I'd like to do, Your Honor, since we could put all those on, I have a whole bunch of financial contempts. I could go ahead and get those prepared, email that to Mr. Gorman. Maybe you could hear that all at the same time.
All right. If you file those, Ms. Sartain, and it's appropriate to schedule those, and Mr. Gorman served with a copy of those, then we'll look to schedule those as well. Okay.
Okay.
All right. Mr. Gorman, Ms. Sartain, on behalf of Ms. Gorman, do y'all have any questions about anything in the order today?
No.
All right. Mr. Gorman, you understand?
Yes, sir.
All right, so tomorrow at the Hall County Detention Center, let's just verify, that's going to be at 3 p.m. Is that correct?
It's actually, Lauren's in school right now, so, it'd be 4:30. So I'll be there at 4:15 tomorrow, and I expect Ms. Gorman to be there at 4:30.
Is Lauren in school at the present time? Which school system does she go to?
Beaufort City.
Beaufort City. Okay, very good. So if she's in school, And that would be 4:30. Are you in agreement with that, Ms. Gorman?
Is that time okay?
Yes.
4:30?
4:30. So, Mr. Gorman, you're going to be in the side of the detention center at 4:15. Mr. and Ms. Gorman, I get frustrated in part. Y'all are both incredibly smart people. I know that. Y'all know that. You've been very successful. You made millions of dollars in your businesses that you had together. I know that y'all can comply and that y'all can work together to do this, and that you can each give some concessions to make this work for your children. And that's why I get frustrated. Sometimes parties may not have the capacity to understand what the court's asking them or ordering them to do. But I know both of you are very intelligent individuals, and you're able to craft some cooperative agreement to be able to make this work and or otherwise to comply with the black and white letter of the order. Okay? All right. That's what I expect. We'll set dates for those other matters. You'll receive that by email. Is email notice sufficient, Ms. Sartain and Mr. Gorman?
Yes.
Yes.
Right. And we will proceed accordingly with those once those are set. And those may be by Zoom or those may be in person, depending upon guidance we receive from the Georgia Supreme Court's judicial emergency order extensions and or from any orders of the Northeastern Judicial Circuit. Okay?
Yes,
All
sir.
right.
Thank you.
Thank you, Your Honor.
Have a good day.
Bye-bye.